Welcome to Embargoed, a podcast featuring intelligent talk about sanctions, export controls, and all things international trade for trade nerds and normal human beings alike. I am one of your hosts, Brian Fleming. I'm here, as always, with my intrepid friend, colleague, and co-host, who is looking out for his health and well-being and bodily warmth today, Mr. Timothy O'Toole. What is up, Tim?
What's up, Brian? It was negative 27 when I got up this morning, and so I thought a hat was in order for most of the day. Doesn't matter how airtight your house is, negative 27 is still cold.
That is no joke. I can attest to that. It's been a while since I've been in a location that cold, but my hat is off to you, as you have your hat on today to weather the cold, to brave the elements for the podcast today. So thank you, as always, for doing your best to go above and beyond, as you always do. So thank you.
My pleasure, Brian.
Welcome to everybody to the pod, to the latest episode of the pod. Thanks to everybody who listened to our Russia extravaganza. Not surprisingly, there's going to be some more Russia content today for anybody who hasn't been living in a hole in the ground for the last couple of weeks. Before we get to the agenda for today, the usual message to start: we're not giving legal advice, we're not sharing any confidential information, and in all information that you hear and opinions that you hear are mine and Tim's. Even though they may be impacted to some degree by the extreme cold, they are still entirely our own, and you can blame us if you disagree with them. If you enjoy the pod, spread the word. Please subscribe, give us a rating, hopefully a 5-star rating. You can get us anywhere you find your pod content. And let's get on with it. So again, not surprisingly, we are going to start with some more Russia. We're gonna not really rehash all the ground we covered last time, because we obviously spent a lot of time on Russia, but a few discrete issues that I think warrant more discussion that we're going to cover right at the top. In particular, the recent announcement about the potential deployment of the foreign direct product rule with respect to Russia in a somewhat novel, though not entirely novel way. So we're going to start with that. We're going to then go to one of our other favorite topics, which is Iran, and in particular, whether it is truly now or never for JCPOA 2.0, as it appears to be. Perhaps we declared JCPOA 2.0 dead essentially on our year-end podcast last year, so we'll see if that is right or wrong, but we're going to talk about that a bit. And then we're going to talk about a recent development in a pretty high-profile prosecution of an MIT professor, which was just announced last week, a dismissal of an indictment against him, and whether that may signal the end of DOJ's so-called China initiative. So we're gonna hit on that. That's been a while since we've talked about that, so we'll come back to that. And then in the lightning round, we're going to hit two topics very briefly. We're going to go back to some Helms-Burton related litigation. We haven't talked about any of the Helms-Burton lawsuits in quite some time, because most of them have kind of petered out. There's a notable one in Florida that's still going against some of the major cruise lines. We're going to talk about that briefly. And then we're going to end with late breaking news that just came out today, which is the multi-agency business advisory that was just issued today relating to dealings with Burma. And that'll be our show for today. So before we brave the cold to get back into more Russia-related talk, any thoughts, Tim?
Just
before we get started?
Russia all the time. To paraphrase the Brady Bunch, Russia, 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 Russia.
Russia, Russia, Russia. That is indeed.
Or Marsha.
For those out there who are too young to remember the Brady Bunch, Tim providing
I just dated myself.
Helpful guidance. So let's jump right into it. So topic number one, we're going to start with Russia again. And as I said, we're not going to rehash everything that we covered the last time in terms of what could be coming on the sanctions front. What we really want to do is kind of pivot to some new developments that have trickled out over the last few days. So last weekend there was an article in the Washington Post. I think they officially broke this news that the U.S. government is thinking about imposing again, somewhat novel, although not entirely unprecedented use of the export control rules to really inflict some pain on Russia. And the way it was described and the way that it has subsequently been described by some senior U.S. government officials and some press availability is that they would essentially deploy something akin to the way that they have implemented the special foreign direct product rule with respect to Huawei and the Huawei entities that are on the entity list, which, as all of you out there, I'm sure, recall and know all too well, relates not only to extending the reach of the EAR beyond its normal scope, but in particular to, with respect to the foreign direct product rule, doing that in a way that will impact factories where there will be, and facilities, and in this case, fabs that manufacture semiconductors with particular types of U.S. Origin software technology and equipment. And so what was cited in the one example that was cited in the U.S. In the Washington Post article in particular was the idea, and of course the idea here is, again, rather than just targeting one company and the affiliates that are on the entity list with this type of rule, this would potentially be broadly targeted at Russia, and in particular some strategic industries in Russia that are heavily reliant on chips and semiconductors that would likely fall under the coverage of this expanded rule, namely civil aviation, maritime, certain high technology sectors like artificial intelligence, quantum computing, and other kind of military industrial type enterprises and industries that are very strategically important to the Russian regime and in particular to Vladimir Putin. So this would really kind of hit them where it would hurt more so, not more so, but in a different way than the OFAC sanctions that we talked about primarily the last time. So I want to, and again, this is, and as it's being reported, this is something that's being discussed very closely with allies and others to ensure that whatever is rolled out is coordinated in a way so as not to adversely impact interests that are aligned with the U.S. and would be very laser focused and targeted just on these Russian industries that I mentioned. And the one example that they pulled out in the Washington Post article, which I think is a useful one to bear in mind, is the idea that, and as again, anybody who follows this knows, when the special Huawei foreign direct product rule was rolled out by the Commerce Department back in 2020, TSMC, which is of course one of the largest chip manufacturers in the world, and Huawei was a huge supplier for Huawei, it basically concluded that they could not supply Huawei any longer, or largely could not supply Huawei consistent with the restrictions that were imposed by the new foreign direct product rule. And of course, there have been a lot of things in the news about not necessarily TSMC, but others in the supply chain coming to Commerce, trying to get licenses. We're aware of at least a few instances where that was successful, but by and large, the licensing requirement that would be now imposed with a policy of denial, presumption of denial, would make it practically impossible to supply these industries in Russia if this type of rule were actually implemented here. So with that, there are still so many question marks in terms of what's going to happen with Russia and Ukraine. Obviously, a lot of noise, a lot of blunders, a lot of sort of war of words flying back and forth between a lot of different countries and a lot of different parties over the last few weeks. But with this in particular, let's start here. I think we'll cover a couple other new wrinkles to this, but let's start here. Tim, what are your reactions to this? How do you think this could play out? Do you think this would be workable from the U.S. side, and how is this going to impact people more broadly than just the Russian government?
So it's interesting because it does seem to try and hit Putin where it hurts. As I've heard the policy described by some of the administration officials, they've essentially taken this growth area or this modernization area of the Russian economy that President Putin has singled out as critical to Russian growth and has been trying to kind of build AI and quantum computing and that sort of infrastructure in the Russian economy, and said and all of which or much of which comes from U.S. origin technology, and said we're going to cut this off. Like, you're not going to be able to get it anymore if you cross the line into Ukraine, and that in theory is a very potentially effective policy, and it's one that I heard the policymakers describe as a medium-term policy. So it's not going to have an effect right away, but in terms of Russia's growth and in terms of Russia's building of infrastructure, it's simply not going to have the possibility of it's not going to have the possibility of being immediate, but it will prevent longer term growth or medium term growth in those sectors. So it could be very, very effective. I think it's going to have to be combined with other policies, and I also think that the test of this, because it's foreign direct product rule, for enforcement purposes, you're going to need a lot of support from the allies. So to the extent that these products are being built in Europe with U.S. origin technology, if the allies aren't unanimously in support of it, or at least a great majority of them in support of it, there'll be enforcement challenges, because gauging whether or not U.S. origin technology is really sufficient or is within these products, and whether these are products that are subject to the rule for essentially an export that's coming from a different country other than the U.S., it could be difficult to enforce unless you got a lot of cooperation from other countries.
Right, and I think that's a great point to highlight, because obviously I mentioned TSMC in Taiwan, a country that is very heavily invested in staying on the good side of the U.S., especially as a buffer between it and China. China, though, I think is the interesting kind of, shadow player behind this, because to the extent that there is alternative supply to be found, it's probably coming from China. And there's a lot of data that's out there and a lot of reporting on this, that Russia's already sourcing a lot of its tech and a lot of its and a lot of these types of items from China. And so it'll be interesting to see if China, just happily kind of comes in to fill the void there, which I'm sure they will try to. Again, this is not overnight you will see the results of this. It will take a little time for this to play out, given the way supply chains work and given whatever will be built into the rollout of the rule in terms of a buffer and perhaps a wind down period. I will also say that related to this, there's some talk about so this, I think, is the big one, from the strategic choking off Russian industry, key Russian industries from this type of technology and these types of chips. And again, I think it is not really disputed that Russia just doesn't have the capability to kind of gin up alternate supply domestically, right? They're going to have to go somewhere else. To Tim's point, if that's Europe, hopefully the European allies are well aligned with the US, and that won't happen. If it's China, then that's a different story, and we assume that there will just be even a harder pivot to China than there already has been. But the other piece is this rule to some degree, but then even more broadly, there has been noise in the past couple of weeks about essentially just an export ban to Russia that would resemble something akin to what we have with Cuba and Iran and other countries, with very narrow carve-outs that would, this foreign direct product rule extension, if it is put into effect or implemented, would potentially trickle down to many products that are not necessarily intended to be caught by it, or not the primary strategic, objective of this rule, but might extend to consumer electronic goods and other things like that are going to more broadly impact the Russian people. But then there's also talk of this broader export ban that might go into place, and that's at least being considered as well. And so I don't know what your thoughts are on that, or how I think to some degree it's hard to, the hardest thing right now, I think, is deciphering kind of, it's a little bit of a signal from the noise kind of problem, right? Because there is a lot of big talk that's going on both sides, on all sides, not just the US and Russia, but on the allied side as well, in an effort to have some deterrent effect to prevent the invasion of Ukraine, right? And so what actually plays out and what happens on the ground literally will impact obviously what tools and what measures are going to be taken, and then also when push comes to shove, what is going to be palatable and not palatable in terms of the collateral consequences that come from the more coercive economic measures that the U.S. is willing to take, whether it be imposition of economic sanctions or imposition of export controls that could really choke off certain aspects of the Russian economy. So I think that's a really hard thing to know right now in terms of what that will look like. But what are your thoughts on that sort of broader export ban, which would really be that would be quite a dramatic step as well?
Well, I think like the export controls, a lot of its success or failure is going to boil down to whether the allies go along. And, with respect to a pretty, targeted export control like that we've heard talked about, that strikes me as having some chance of success on a multilateral basis because other countries could get on board with that. That's really not that much different from where U.S. law is now. It just would be a change in licensing policy, but it would otherwise be, relatively continuous, and other countries, could probably be persuaded to go along with it because of the U.S. nexus. I think an export ban is different than many countries. Embargoes are really, the U.S. is one of the few countries in the world that actually does embargoes. Most other countries, certainly Western Europe, they don't do embargoes. They do lists often, they'll do export controls, but a full-fledged export cutoff is something that will be very difficult to persuade the allies to go along with, in part because that's not really how they operate usually, but also because, from the U.S. perspective, Russia is a relatively minor trading partner. For a lot of the European countries, Russia is, one of its bigger trading partners, and I'm thinking here, largely of Germany, but there are, the rest of the EU trades with Russia quite a bit, at least compared to the United States. And so getting other countries to go along with this will be difficult. I think that if you can't get other countries to go along with this, so if the U.S. imposes an Iran-type scenario where, there's these primary sanctions from the U.S., but nobody else goes along, what you'll have is the situation you were just talking about with respect to China, but kind of multiplied. That is, essentially the U.S. will drop out of the Russian economy from a trading standpoint, but others will step in, and not only the Chinese, but the Western Europeans too, if they won't go along with an export ban. And so at the end of the day, it may not be very effective if you impose an entire, export ban, because Russia can make up the slack from other trading partners, including potentially those in Western Europe and the EU that don't go along with this sort of thing. So it just highlights, in my view, how important it is to get consensus on whatever they do, because otherwise it's likely to be relatively ineffective and could wind up hurting the U.S. economy in the long term by essentially, knocking us out of the Russian market while others come in and stay for the long term.
Yeah, the economic interdependence of Europe and Russia is not to be understated. And in fact, we got a couple of comments from people on the last pod about that very fact, and just sort of underscoring the point that the harsh, unprecedented, overwhelming sanctions that the U.S. policymakers are touting right now are going to be difficult in some ways to not only implement, but to get our allies to really get on board with, because it is going to do them a lot of harm as well. And in fact, I just saw an article today, I think it was in the New York Times, that talked about the fact that the new German chancellor may be wavering a little bit on sort of how hard to come crashing down on Russia in the event that there is an invasion. So that certainly doesn't bode well for. I mean, the U.S. and Germany have been pretty well aligned and in lockstep publicly on having to be sort of tough on Russia at this point on this issue. But if that is in fact the case, then that certainly doesn't bode well for the prospects of sort of long-term success of this strategy if one of our key, if not our key ally in Europe on this issue is perhaps having second thoughts about how to proceed. But on that point, let me pivot to a couple of kind of final issues for now on this, and obviously I'm sure we'll be back on this in a couple of weeks, but two other items to bring up. So one is gas supply to Europe, which again is one of our favorite topics, and obviously we covered this to some degree with Nord Stream 2, but there's been a lot that's being discussed on that front in terms of if Russia is to is to choke off or to try to extort from Europe certain of its demands by virtue of, meddling with the energy supply, then what's going to be done about that, and trying to again take some measures and signal that there will be some pain inflicted to deter that. And then the other is the idea of perhaps let's call them preventative sanctions or early sanctions or prophylactic sanctions that some I know have been advocating for, at least in the US, that why don't we do something now to inflict some pain on Russia, just for engaging in the troop buildup and the menacing behavior that they're behaving in at the moment. Just let me kind of throw those things to you, because I know we've talked about these over the last few days. So maybe a couple of thoughts on this idea of kind of preventative or prophylactic sanctions that would be actually imposed perhaps before any kind of ultimate malign activities were to be taken by the Russians.
Yeah, I mean, I've heard that talked about a ton, and in fact, on CNN this morning, I saw some questions from the White House on those sorts of issues, and their response, I'm actually generally in line with what their response was, which was, sanctions are supposed to be a deterrent, and so you tell a country, if you behave like X, you will be sanctioned, and what we've said to Russia is, if you cross that line, you will be sanctioned. If you sanction them now, then the incentive for them not to cross the line goes away. You've essentially already kind of impose the cost of crossing the line. So at that point, they're in a spot where they have nothing to lose. And to be sure, you could escalate after that. But I think sanctions are most effective, and especially given the logistical issues that we've talked about, it's going to be difficult enough to make the sanctions effective in any sense, because of all of the challenges that are there with respect to enforcement. So if you impose the sanctions now, you've imposed the cost. You've also potentially exposed some of the weaknesses of the sanctions beforehand, and you've given the other side no real incentive to back down because they've already been hit with the sanctions. And it just as a purely, rhetorical matter, at least some of the kind of the Russian media, the Russian state media that's been going on now has talked about how, the U.S., the bad U.S. and the bad West are really trying to cripple us with sanctions. And so you kind of play into that motivating rhetoric that is essentially driving the Russian government in terms of trying to, lay the groundwork for their people for an invasion of Ukraine as almost a defensive measure. You kind of help with that rhetoric by essentially striking first instead of waiting for Russia. And I get people's desire to move fast and to impose punishment on Putin for simply creating this sort of controversy for his own reasons, which really goes against international norms. But I just think that there's a lot of reasons that the administration is smart to go slow here, because I think if you move too fast, you risk escalating a conflict that otherwise you might have been able to draw down from.
Yeah, one thing that is abundantly clear as well is that the U.S. government is obviously expending a tremendous amount of time, energy, effort, and resources at the moment, gaming out all kinds of contingency plans for what they will do or what they are willing to do if X were to happen or Y were to happen or Z were to happen with respect to Russia's actions targeting Ukraine. So I think there is a lot of kind of gaming this all out. Obviously, there are still diplomatic discussions going on at the moment that hasn't sort of completely fallen apart as of now. So that is still certainly the path that the U.S. is trying to pursue. But what is being made abundantly clear to Russia and the rest of the world is we are prepared to act if, in fact, there is the red line is crossed, and you, Mr. Putin, should expect a lot of pain. So again, what precisely that'll look like, it now seems that we're getting a little bit better picture of kind of how robust that package of sanctions and export controls restrictions could be, but it's still sort of where we come down ultimately is going to depend on what the actions are at the end of the day. I think that is going to dictate sort of how harsh this is going to be and what's going to be targeted. Maybe one last. Sorry, go ahead.
No, I was just going to jump in on one of the other points that you made, which is the gas supply. I mean,
Yeah.
that issue also is really complicated because on the one hand, because it is such an important industry to Russia, it is an obvious topic for, or an obvious target for U.S. sanctions. So, I think we talked about it on other podcasts about the possibility of, putting, large Russian state-owned, energy companies onto the SDN list would be a really significant sanction for Russia, but it also would be a really significant sanction for Europe. And so some of the talk that I've heard now is that, that Russia might actually just cut off the supply. That is, it almost puts itself on the SDN list as a way to make Europe feel pain by essentially cutting off transactions with Europe before the U.S. cuts off transactions with it. And so it does strike me as very complicated because, I think in the news today, President Biden is meeting with the Emir of Qatar in order to get alternate supplies in case Russia actually does take the step of cutting off the supplies itself. So it's really very complicated in terms of what sanctions to impose and whether they would hurt Russia more or they would play right into Russia's hand.
Yeah, how the levers get pulled to achieve the objectives that are desired here is a very complicated set of questions and analyses. So I don't envy the folks that are sitting in the skiffs around Washington D.C. trying to game all this out at the moment because it is incredibly complicated. It's incredibly high stakes and it will have obviously potentially a very lasting impact on many different aspects of not just what's happening between U.S. and Russia, but Europe and Russia and China, and many of the biggest sort of global dynamics from the trade and foreign policy standpoint are really kind of on the line here in terms of what may happen. So how this plays out is going to be fascinating and also is, it's fraught with a lot of peril from all sides. One last thing that I will mention before we move on to Iran, one thing, just to go back for 1 second to the foreign direct product rule, one thing that I know that Tim and I both experienced when we lived through this in the wake of the Huawei rule being implemented was the difficulty and in some ways the lack of preparedness on behalf of entities, certainly outside the US, to kind of wrestle with what the new rules really meant for them. People who were in supply chain or had relationships to Huawei who were very unclear whether or not the nature of their relationship would potentially run afoul of the new restrictions. And at the end of the day, for people who have not dug in on this, I mean, doing a foreign direct product rule analysis to understand whether or not a particular item could be subject to the restrictions and could now have a licensing requirement is often a very technical analysis that takes some time and takes some expertise. So to the extent that there's anybody out there who's listening to this who has any question as to whether or not this might impact them, I would certainly encourage you to start thinking about that now. And I would use obviously the Huawei blueprint as your roadmap for what might be covered if you think that you are potentially in the crosshairs on this, because I think this is being signaled very clearly as one of the likely things that would the first dominoes that could fall if there is incendiary action taken by Russia. So that's that's kind of an obvious point, but at the same time, I think something that shouldn't get lost in all of this, and something that we know all too well is it's a difficult thing to kind of sort out and to get comfortable with, and to make sure that that you're going to be staying on the right side of that, because it can be incredibly complicated.
Yeah, one of the things that I'm doing, and I know you are as well, with all of our clients is encouraging them to review all of their Russian, touch points and transactions in order to figure out, what they'd need to do in case, sanctions come into play. Now, with respect to these sanctions that have been kind of almost directly threatened by the U.S., you've definitely got to do that. But I do think that, from just a Russia writ large standpoint, if you if companies should be reviewing their Russian connections and their Russian transactions with an eye towards what if, Russia is put under embargo, or what if a bunch of the SSIs currently go onto the SDN list, or what if, the Russian oligarchs are put onto the SDN list, and we have a situation like we had with Rusal and ENC Plus and those sorts of or EN Plus, that those sorts of companies that are owned by, or majority owned by Russian businessmen who wind up on the oligarchs list. Like that is something that companies ought to be thinking about, because it could happen very quickly after there's an invasion. I mean, the U.S. has said clearly that the second that the invasion occurs, what they called expansive, draconian sanctions are going to go into effect, and U.S. companies will be left to deal with them right away. So they ought to be getting ready now, just in case.
Yeah, never too early to start your sort of Russia-focused risk review at this point. So I think that's the bottom line, which again is something that we've said, and that I think everybody in the compliance world understands, but is bears repeating, because I think there's a lot at stake here, and there is going to be, in all likelihood, significant disruption to the status quo if this does take a turn for the worse here in the next few weeks and months. So with that, let's leave Russia for the moment. Let's turn to another one of our favorite topics, which is Iran, and let's dig into whether it truly is now or never for JCPOA 2.0. Tim.
Got it. Well, we keep coming back to this topic, and we keep thinking that, either the JCPOA has to go into place because both sides really do want a deal, because, the Iranians want the trade and the U.S. wants the nuclear security that the prior deal gave them. But alas, it has slipped away over the past year, and we're a year into the Biden administration, and it looks like there's no deal at this point. In the last few weeks, the administration has started talking about time running out. Now, we've already talked about time running out, months ago, because the length of the deal and the benefits that each side gets are limited. And so the longer that you wait to go back into the deal, the less time is left in the deal. And I think the less likely it becomes. In recent comments from the administration suggest a matter of weeks before the talks end, although there have been reports now of some progress in those talks. And so, although we have kind of declared several times that the JCPOA looks dead, it doesn't quite look dead yet. I think we're down to the final 3 weeks or so. Although, who knows? Because although that's what's coming out of the U.S. administration, the Iranians are suggesting that that's just a talking point, and that that's just an artificial deadline, and they're not going to be driven by artificial deadlines. So, we may be close to a deal, we may not. The administration has suggested we'll know for sure within the next few weeks, and I think that's probably right, because I think time, just for a variety of reasons, and not just an artificial deadline, is not on anyone's side if they don't cut a deal soon. But we'll see. I think that the signs out of Vienna are more positive than they've been in a while, but still, no deal.
A point that's been made by many, including Tim, is the fact that it seems Russia and China are committed to getting a deal done, and have now leaned on the Iranians to get them to perhaps back off of some of their more unreasonable demands, and that is perhaps what has jump-started this slightly more hopeful stage of the negotiations. We shall see. I think that another point here that is, again, bears some consideration and some thinking about is, if there is a new deal, if we do have a JCPOA 2.0, what does that actually look like? Are we truly just reverting to the old deal that was, now set in play, set in motion, 6-7 years ago, a long time ago now, in the grand scheme of things? Are we really going to revert back to U.S. simply lifting all of the sanctions that were reimposed throughout 2018, in exchange for, again, the sort of dismantling of the nuclear facilities and capabilities in Iran that were pledged as part of the deal, which of course have made significant progress over the last few years since the U.S. pulled out. So there's even talk about whether the European parties to the deal would potentially try to exercise their rights under, the snapback provisions and other things, because they're not getting the benefit of their bargain with Iran continuing to enrich and take steps to further their program. So, what that looks like, obviously the Iranians want more relief, the U.S. wants more security, a lot of other parties, Israel is still in the mix, not happy with any of this, wants, sort of more maximum pressure style sanctions imposed on Iran, it seems, and they're not a party to the deal, but they are, influencing the discussions to some degree, at least through their external actions. And so, I think, again, we still have more questions than we have answers at this point. I do think that we wanted to, despite essentially declaring this dead, a month and a half ago, in light of the talks that it started up at the very end of December and have kind of continued on in the early part of this month, I do think it's worth kind of putting this back in focus, because it does seem that we might get to some clarity on this. Again, I know we sound like a broken record. We've said this, I don't know, 3 or 4 times, but it is, the U.S. is going to risk sort of being, not that this matters in politics or policy making, but that we're the country that cried wolf on this and said, "Yep, we're done," and then, the sort of, you keep grabbing the football away as they run up to try to kick. So I don't know what's going to happen here, but it'll be interesting to see next few weeks.
2 other quick comments. I mean, one of the things that I think might be a driver here is that, it's not unrelated to Russia, and it's not unrelated to global oil prices. Global oil prices are very, very high right now, which is, as everybody knows.
Correct.
And that is creating, political danger for the administration, because no politically democratically elected government, and maybe even undemocratic governments do well when the price of oil is high. And so, part of the reason that the price is so high is that the supply has been deprived, the world oil supply has been deprived of Iranian oil for at least since the maximum pressure strategy went into effect. And so one driver could be the price of oil. A related driver is that if there is a conflict with Russia in Ukraine, the oil supply from Russia is likely to either, be pulled back by Russia, affected by the incursion, or the subject of sanctions itself. And so the idea of Iranian oil starting to come back into the global economy, at least to the non-U.S. nexus part of the global economy, is probably something that is appealing to the U.S. policymakers. In the same way, I think that the flip side of this is I saw some articles talking about how maximum pressure had really greatly reduced the supply of global oil, so that the Iranian oil in the world's oil supply has really dried up since maximum pressure. And the way that the article was written, it was as though that was a big success story of maximum pressure. And I guess if the goal of sanctions is to drive down the supply of a particular oil from a sanctioned country, then yeah, it was a success. But my understanding was that the point of sanctions was to stop their nuclear program. And in that sense, it was a massive failure, because the fact is that, and I don't think there's any dispute about that, Iran is way, way closer to building a nuclear bomb than it was when we backed out of the Iran deal, when we backed out of the JCPOA and started putting this maximum pressure on. So yeah, if the goal was to dry up Iranian oil sales, that maximum pressure did pretty well. If the goal was to actually stop Iran's nuclear program, it was a massive failure. And so that also, in my mind, explains why it is that there's pressure to get back into the deal, because we can dry up the Iranian oil supply all we want with sanctions, but it didn't stop them from getting the bomb. And so if we really want to stop them from getting the bomb, getting back into the deal may be the best way to go.
Yeah, I guess the counter argument would be that it's that pain of the depriving them of revenue that has at least brought us back to a point where they're willing to even discuss this. But I think that the counterpoint to that would be exactly what you said, which is now they're just emboldened, feeling like they should ask for more because they've kind of weathered the storm, or at least have, relatively speaking, weathered the storm. They're not. I don't think there's any narrative that would suggest that the Iranian economy is thriving at the moment, but all things considered, it is kind of hanging on, and and perhaps could hang on for some time longer, even if there is no deal reached. So we shall see, but we wanted to kind of put that back into focus for everybody, because this is one that we certainly hear from people about pretty regularly in terms of what is going to happen, what will this mean, and I think we have to keep a close watch on that, along with Russia and Ukraine. So that brings us to topic number 3, our last main topic for today, which is DOJ's China initiative. And wanted to talk about kind of 2 aspects of this, starting with what was a pretty, look, I will caveat by saying, as anybody who listens knows, this is my former colleagues in the National Security Division sort of oversee the China initiative and oversee the investigation and prosecution of the criminal statutes that are kind of part of the China initiative push, including the cases that have been brought against so-called non-traditional collectors, which, for those out there who don't know what that means, just means not trained intelligence officers who are deployed to various countries to obtain information, obtain valuable technology, and bring it back or send it back to the home country. And that's exactly what we had in the news recently, which is the case against the MIT professor, which was just dismissed. This is Gong Chen, and that was just dismissed about a week ago. And this is and so for those who weren't tracking this too closely, he was not charged. This is all relating to what were alleged to be material omissions on grant applications to the DOE. Essentially, that's what it all boils down to. And the idea that he did not disclose ties and funding that he had with certain aspects of the Chinese government and Chinese entities, and foreign bank accounts and the like. And so that's a oversimplification, but that's essentially what it boils down to. Is he was charged with wire fraud, failing to disclose file an FBAR for a foreign bank account, false statements. That was the sum total of what he was charged with, or what he was indicted on. And that case was dismissed in whole because apparently, in the course of the post-indictment follow-up that DOJ was doing, they spoke to folks at the Energy Department who confirmed that they would not have expected him to disclose any of these things, and therefore they couldn't really have been considered material because they wouldn't have impacted just the way that the grant application process was set up. That's just not information that was necessarily called for, so he wasn't necessarily hiding anything or trying to obscure the fact that he had these ties. And in any event, they wouldn't have necessarily changed the outcome of the application process. Is sort of, again, I'm oversimplifying, but that's essentially what it boils down to. And so the case was just dismissed. This is a case brought up in district court in Massachusetts. New U.S. attorney came in, they looked at the case, and they just dismissed. So I think that what I want to highlight here is a couple things, and then I'll throw it to Tim. So if you look at first of all, the priorities of DOJ's China initiative as they are set out, and they're still on the website. I went yesterday to look, and they're still there. It is still technically, in force, being pursued every day by the good folks at DOJ. Although there have been some, at least anonymous confirmations that they may be kind of folding up the tent or rebranding the initiative in some way. If you look at everything under there, which is, combating economic espionage, ensuring that sensitive technologies are not, stolen or exported illegally back to China from the United States, using the CFIUS process to protect U.S. interests in sensitive technologies and critical infrastructure, etc. Those things are not going to change. Those things have been the policy of the U.S. government and DOJ. Those things are going to remain at the forefront of what certainly the National Security Division is doing with respect to China every day. And I don't think that any of those are particularly controversial goals either. And if you look at the laundry list of cases that have been brought in service of those goals, it is lengthy, and I don't think you would find too many people that would say that is all that problematic or surprising from a U.S. National security and sort of law enforcement interest perspective. I think what is probably going to change is certainly, again, there's signals that the whole program, this initiative, is perhaps going to be jettisoned and it's going to be kind of taken down to at a slightly lower register. This idea of non-traditional collectors that I mentioned at the outset, and this is something that I can attest to the fact is something that has been talked about and an interest of law enforcement and the national security apparatus in the U.S. for a long time, not just with respect to China, with respect to other countries, but I think it sort of ends up being China ends up being the sort of poster child for this issue or this phenomenon. These are hard cases to investigate. They're hard cases to prove. They're hard cases to charge. There is, I think, as evidenced by what you saw in this most recent case with Gong Chen, the proof that that the government thought they had it just fell apart. They didn't have the willfulness evidence. They didn't have the intent evidence. And then at the end of the day, when they got a better look at all the pieces, they realized that they were just off base in how they were interpreting the facts. And I think that is, if there's any lesson, I think that might be the lesson, which is when there is a clear narrative that the government and DOJ are looking to feed to some degree, which is, and if you look back at the press conference from when Professor Chen was charged, is, this case comes down to loyalty to China at the, sort of at the expense of what should have been his loyalty to his new country. He was a naturalized U.S. citizen. He's a U.S. citizen, naturalized U.S. citizen, and his obligations in pursuing grant money from federal agencies essentially is kind of how it was kind of again encapsulated, and that's a very tidy narrative that look, it is applicable. It is correct in some cases. It just appears that it was wildly off base in this case, and when DOJ has to suffer kind of a black eye in this regard. And again, I'm biased here. I know some of the people that were involved in this case. They're good, reasonable, level-headed people who are not trying to sort of sandbag anybody. So even people who are trying to do it right get it wrong sometimes. I mean, that's just a reality of it. And the costs are incredibly higher and incredibly dire when it comes to what has now happened to this person's life and his liberty for the last year. I think that does warrant some reevaluation as to whether those are the type of cases. That class of cases is really what we want to be devoting the resources to and the effort to in the long term. I think it's worthy of further discussion and scrutiny. And I, in some ways, tip my cap to DOJ to at least admitting that they're willing to sort of reevaluate this and think about how they want to do things going forward. Again, I don't think that you're going to see at the end of the day a jettison. That they jettison sort of all of the goals of the China initiative. I think they are very much here to stay for the most part. But with this area in particular, when there, is not even an accusation in the indictment that there was, sort of a theft of trade secrets or an illegal export of controlled technology or items or software, then I think those are just very difficult cases. They're very, very difficult cases. And this kind of theory and this approach that has been taken in some of these cases, which has resulted already in some pleas and some custodial sentences, I question whether that's going to continue or not. So that's kind of a small picture, big picture view of the whole thing. Obviously, let me kick it over to Tim to sort of chime in here as well.
So I have some relatively strong thoughts on this. I mean,
yes.
First,
I know you do. I know you do. Yes.
So first, let me just start by saying that the goals of the China initiative, the stated goals, that is like stopping economic espionage by China, are really important, and they are a real problem. But there are, in my view, big problems with focusing on an initiative like this in terms of resources and in terms of focus from the get-go, I'm not saying you shouldn't do it, but you have to do it in a really careful way, in part, especially when it's focused on a particular country, and then the defendants often seem to be people who have some ties to those country in terms of nationality. That it strikes me that when you're going to have an initiative, the problem with initiatives is that you have an initiative and you're going to need to show results. So you're going to need to get pleas. You're going to need to get convictions. And so there's this push to get results in that particular area that I think is problematic. I don't think I'm not saying it means you shouldn't always do it, but you need to be really careful with it. And then when you kind of add this twist where you're potentially focusing on nationals of a particular country or former nationals of a particular country, you really do need to be extra careful in that area. And I think that, the facts of this case, but not just this case, kind of other cases show kind of what can go wrong if you're not careful. And what I mean by that is, first of all, a press conference where you're essentially accusing this guy, and all he's been charged with is kind of not disclosing things to the DOE. He wasn't charged with being a spy. He wasn't charged with economic espionage. And you accuse a guy who's been a citizen of the United States for 20 years of not being loyal to the United States because he filed a grant application that you didn't think was complete, is problematic in and of itself and doesn't show a sensitivity to these kind of potential discrimination issues that could arise in this sort of initiative. But second of all, it's not an economic espionage case. Like, why is this part of the China initiative? It's at best a failure to disclose things on a grant application type case, which is not really unique to China or anywhere else. I mean, if you think that there's not full disclosure, fine. And I guess the claim was that he didn't disclose his ties to China, but at the end of the day, it wasn't the sort of case that really should have been part of this initiative. And it seems like a case that was brought in a way because they thought they could make that prosecution because the evidence was entirely within their possession, as opposed to an economic espionage case that often has links to China that are much more difficult to investigate. And so I really do think that that sort of prosecution does, the fact that it's there, and let me also, give a shout out to Rachel Rollins, who's the new U.S. attorney in the District of Massachusetts, who was previously the elected prosecutor for Suffolk County, who really, to her credit, came in and ordered a review of this after they found out that the Department of Energy really wasn't backing up their case, and did a very brave thing by dismissing this case, because everybody gets a black eye when they dismiss a case like this, and being willing to take that is what, the hard sort of decisions that the good prosecutors can and should and here did make. So, this is not an anti-prosecution statement from this, but it's a statement from me that really you need to be careful with these cases. And I think that it warrants a reconsideration of the program. And if they're going to keep the program, they really need to be tighter with their focus on real economic espionage cases and not trying to kind of chalk up wins on, 1001 violations or failure to disclose violations that really don't have anything to do with economic espionage. And very, very sensitive to the idea that, focusing on China is not very far removed from focusing on Chinese nationality. And I'm not saying they did that here, but I just don't think they were sensitive to those sorts of perceptions. And I think that's part of what allowed this case to get kind of out of control. And really, the MIT talked about all the harm that had been done to the defendant in this case and to his family and to they called it the entire MIT scientific community. And I think that it does warrant a revisiting of this policy, even though, as I mentioned at the beginning, and as I know you agree, the goal behind this policy is extremely important, and we need to figure out a way to do it, but we have to do better.
Yeah, and I think just as a well said, and I think as a final note, I would just say that the thing that I come back to, and that obviously as a former prosecutor, but now on the defense side, I think about a lot, is the idea of, and Tim, this is really what Tim was alluding to, was the idea of charging decisions. And I mean, these are, and I can attest to the fact that being on the inside, these are things that are heated, debated with a lot of, heated discussions between various actors and factions within the Justice Department. And I have no doubt that was the case here and has been the case with some of these similar the kind of grant application, false statement, type of cases that don't rise to the level of, look, there was an illegal export. There was theft and economic espionage on behalf of China. There was, the sort of higher order, perhaps, easier to see, easier to feel like this is a righteous prosecution type cases. These are essentially a class of cases that was almost created as a outgrowth of this initiative, or a precursor to this initiative, and an emphasis that was only recently kind of identified. And that's not to say, again, that this is not necessarily an area that is worthy of further scrutiny and an intervention, perhaps by DOJ and the government, to protect U.S. interests. But as Tim said, it has to be done very, very carefully, and it's nobody's ever going to have it 100% right. We can't expect that of anybody. And to Tim's point, when it calls for reevaluation and reassessment, and somebody is, strong enough to stand up and say, look, we got this one wrong. We're going to dismiss, we're moving on. And, that's the right thing to do, obviously, but, it's hard. It's a very hard thing. And it's a hard thing to sort of, balance that out going forward. And I know that one way that what tends to happen in these circumstances, and I'm sure as they reevaluate what they want the initiative to be going forward, this may happen, is that there ends up being, more oversight and more approvals and more layers that have to come in, so that some of the, you take the decision-making authority out of the hands of 1 or 2 people and you put it into 10 people, or you rest it at a much higher level with somebody who then has to take into account some of these sensitivities that perhaps are not going to be front of mind for somebody who is much closer to the case and the investigation. And so I suspect that is already happening and has been happening and will be happening going forward. And we shall see how this plays out going forward. But again, also worth thinking about in the broader sense, as we have talked about the China Initiative previously, which is, again, in the way that export controls and sanctions laws are going to be enforced vis-a-vis China, and that CFIUS is going to do its job in reviewing transactions that have some connection to China, and economic espionage of sensitive technology and information is going to work with respect to again, if China is the beneficiary or the intended beneficiary. These things are all to some degree intermingled, but as Tim said, I think there has to be some dividing lines, and there has to be, tough calls that have to be made. But I think that it is not necessarily a failure to look into a case and then say, look, we just don't have enough to charge this person. I mean, that is a hard thing to do. And the momentum, once it gets going, is difficult to stop sometimes, but that is the right thing to do in many cases. And so, as attorneys on the outside, we don't get involved most of the time until the charging decision has been made, but sometimes we do, and sort of trying to, provide context and provide more, arguments on behalf of our clients to hopefully get the prosecutors to understand the bigger picture, so that we don't end up in this situation where you spend, a year of a man's life as he was under indictment and under this black cloud, and now, it all gets taken away, but it'll never get taken away in other ways. So these are serious issues. Again, from this specific case, more broadly speaking, it's something that's kind of, I think, that Tim and I feel very strongly about and have thought a lot about and have, devoted a lot of time to over the years, is kind of thinking through these issues on both sides. And so that's why we want to spend a little time talking about it here at the end of the pod today. So well said. I mean, brave decision, should happen more. Yeah. So with that, let's wrap that one up, and we will move on to a couple of final topics in the lightning round. And with that, let's go back to Helms-Burton, and Cuba, which is obviously a favorite topic of ours as well, which we haven't talked about in a while. And in particular, the summary judgment proceedings that are going on in the Havana Docks lawsuit against the 4 large cruise lines. And in particular, just to set this up, and we're not going to spend a tremendous amount of time on this, lots of different arguments being made as to why this case should end right now by the defendants. But I think in particular, looking at prior OFAC authorizations and other U.S. government authorizations as a basis to protect the conduct that's essentially at issue here, I think is a fascinating thread of this, and that's kind of what we wanted to touch on. So I'll throw it to Tim for that.
Yeah. So as you said, Brian, during the Trump administration, Title III was activated. Title III of the Helms-Burton Act actually had laid dormant since it was passed in 1996 because it required the president to essentially bring it to life. And President Trump, in I think 2018, brought it to life, and lawsuits were filed. And one of the things that Title III allows civil liability for, or imposes civil liability for, is for trafficking in confiscated Cuban property. And so the lawsuit against the cruise lines is that they were trafficking in the Cuban port, or in the Havana port, which the plaintiffs claim was confiscated by the Cuban government from them. Now, there is a dispute in that case over that, or at least, that is one of the contested issues in that case, is whether or not there really was a confiscation, because the defendants at least claim that the Cuban government always owned the port, and so when the Cuban government changed, it's not confiscation to take property from the Cuban government and keep it for the Cuban government. But setting that issue aside, the OFAC issue is kind of interesting because there is a provision of Helms-Burton that does allow for an exception to the Title III that allows that essentially creates a, no pun intended, but safe harbor for it is a safe harbor provision. I don't even know how to say it, but it's a safe harbor for U.S. persons that are engaged in lawful travel to Cuba. And so one of the arguments from the cruise line is that, of course, we're engaged in lawful travel. We were authorized by OFAC to go make these trips to Havana. They knew we were going to Havana. I think they were traveling under the general license to go to Havana, but they were authorized by OFAC, and so therefore they fit within the safe harbor for lawful travel to Cuba. And so if you're engaging in lawful travel to Cuba, you can't be trafficking in confiscated Cuban property. It's an interesting argument, and it sounds right to me. I mean, I have to admit, when I first looked at it, I was a little bit skeptical because, OFAC authorized you to travel to Cuba. It didn't authorize you to traffic in confiscated property. And so to the extent that you are trafficking in confiscated property, that would seem to be, not a defense to say, well, OFAC let me do it, because I'm certain that if you look at the general license, or if they had a specific license, it doesn't say that they can traffic it, that as part of the license they can traffic in confiscated property. But given the safe harbor provision in the law, I think it's a pretty interesting question, and one that they might win on, because if there is this lawful travel to Cuba exception, then they seem to fit within it if they're authorized by OFAC to travel to Cuba.
Yeah, there's an interesting point in the brief from the defendants that sort of calls out the fact that, well, look, the GL didn't specify where in Cuba we could engage in, carrier services with respect, in terms of, providing the travel services that they were providing to customers going to Cuba. And they in fact point out that President Obama himself announced all of this initially from Havana, and so one must conclude that that's not sort of off limits and was otherwise part of that authorization. There's also a few other just really interesting tidbits in there about, a couple of the cruise lines tried to get specific licenses and were told, no, you don't need specific licenses. BIS also had similar authorizations. DHS via CBP had similar authorizations in terms of calling at Cuban ports and being able to return to U.S. ports thereafter. So there was an entire regulatory mechanism that was set up here to allow for this, obviously, back when the rules were relaxed for a few years. And it is one point that was brought up apparently in the briefs and at oral argument was the idea that for plaintiffs to claim that that's not good enough, that you're not able to sort of rely upon a duly authorized pronouncement from the U.S. government by OFAC or by these other agencies that is clearly granting you permission to, act in a certain way consistent with the law and the regulations, that you really need to bring an APA challenge to that if that's your problem. And it's not, trying to litigate that as part of this private Helms-Burton Title III lawsuit is just not the right place to do that. And so it'll be fascinating to see. We kind of wanted to just flag this one for people because it's been a while since we've talked about I think we've talked about this particular lawsuit before at a very early stage, because this is really the one that's been the most active, quite frankly. There has not been much. I know that like John Bolton and many others were sort of licking their chops, expecting that, the Cuban government and all those who benefited from the seizing of property by the Cuban government were going to really rue the day they did that and be subject to all these lawsuits. But they haven't really amounted to much in the last couple of years, and this is really one of the, to my knowledge, sort of the one of the last ones that's still kind of kicking around. And if the defendants succeed at getting this knocked out at summary judgment, which they certainly might, that may be kind of the end of this saga. Of course, so we shall see. We'll keep an eye on that. We'll see what we expect. Obviously there'll be a ruling on this in the coming months, and I'm sure we'll kind of circle back to it again. But an interesting issue, and the one that would bear, I think, further discussion depending on the kind of ruling we get as to what that might portend for future reliance upon general licenses and other changes to the regs that the government is doing, especially when it's kind of a pretty significant change. Obviously, the sort of trapdoor of Title III of Helms-Burton doesn't exist with respect to most U.S. sanctions programs, so this may have some limited applicability, kind of more broadly speaking, but still kind of a fascinating exercise to look at this and think about how it could possibly impact other things coming down the road. So that's really all I wanted to cover on the Havana Docks case. And then the final thing that we wanted to mention in the lightning round and for the pod today, which is late breaking. So we haven't had a ton of time to sort of sit with this, but I think it's worth flagging, and it's in line with other items like this that we've talked about in the past, which is earlier today, just a couple of hours before we started recording, there was a joint advisory that was issued across just about every agency of the U.S. government: state, treasury, commerce, labor, homeland security, and USTR, if I'm not mistaken, that is targeted at highlighting risks and considerations for businesses and individuals with dealings in Burma, and in particular with dealings with entities that are obviously responsible for the coup or that are benefiting from or connected to those individuals and those entities. And so in consistent with what we have seen with respect to Hong Kong advisory, with respect to Xinjiang, with respect to some of these other advisories, this is kind of a sort of neat little branding effort to kind of tie up in a nice little bow all of the various elements of compliance concerns that one could have from a U.S. perspective with respect to Burma, essentially. And it not coincidentally, I'm sure this is just about on the 1-year anniversary of the coup. We are just days away from the 1-year anniversary, so I'm sure that this was, again, time to coincide with that, as some of these other events have been timed to coincide with other notable events in those jurisdictions as well. And it essentially goes through a lot of the elements that we've talked about with respect to the Executive Order 14014 that's targeted at Burma, that stood up the current Burma Sanctions program. That's targeted at some of the key industries there that are impacted, whether it's state-owned entities, it's gems and precious metals, it's real estate, it's financial sector, all of the things that where designations to date under the program have really been targeted, that have been identified as major sources of revenue for the military, and also, of course, highlighting the idea that sort of AML and CTF considerations in terms of any dealings with the financial sector there, in particular in the real estate industry, which is known to be kind of a money laundering mechanism in Burma, people are well aware of. And again, it's just sort of a nice, neat encapsulation of all that in one place that is a handy kind of compliance tool or awareness tool for those that are not already keen to this. Forced labor is another aspect here that I think gets highlighted as well, both on the DHS and the Department of Labor side. So also worth noting. I think that for the most part, I will say that from my experience, my clients who have had dealings with Burma are sort of well on top of this and have been tracking this very closely since a year ago and have made adjustments to their own risk tolerance and their own dealings with Burma already. So I think that for the most part, this seems to be an issue that is well understood. But again, notable that on the eve of the 1 year anniversary of the coup, that this is coming out, and again, as an awareness tool, as a branding mechanism, as a general, kind of effort by the USG to kind of bring this to perhaps a higher level of visibility globally. Just something that, again, hot off the presses that just came out today that we wanted to just flag for everybody really quickly.
Yeah, I mean, any company that has business in Burma should be taking a look at this. I think it's a handy guide. I think it does a good job with, especially in the final appendix, of really chronicling all of the many additional risks that have arisen from doing business in Burma since the coup in February of 2021. I mean, I will say, one of the things that I think is it's in there very briefly, but I think they probably could have expanded on a little bit more. They added, the Commerce Department added Burma to the list of countries that many goods can't be given to military end users and military end uses, or that exports of goods on Supplement 2 to Part 744 can't be sent to those sorts of entities. And given the fact that there was a military coup and that there are a lot of industries that are state-owned, I do think that is a complex question that is one that could arise a lot, because the definition of military end user, as we've talked about here, mostly in relation to China, is very broad. And so my guess is, and I actually haven't had it come up in my practice yet, but my guess is if you tried to look at particular entities in Burma that had some relationship to the government, that they may well qualify as military end users, given that the government now is the military.
Yeah, that's a really, really good point. And I have had this come up a couple times in the last 9 months since they got added to that portion of the regs. And in particular, I think it came as a surprise to certain companies that perhaps if they were exporting certain items that were subject to certain ECCNs, that they were going to need a license to do that now, if they were, or arguably would need a license to do that now, depending on who the ultimate end user is going to be in Burma. I think that is, for whatever reason, it is not. I think because the China, Russia, Venezuela aspect of the rule dominates, it seems, in terms of public perception at least, Burma gets forgotten. I've probably edited more times than I'd like to remember language in certain end use certifications and other things to add Burma into to that recitation, because it does get forgotten, or it's not been updated in a timely way. So that's a really good point, and is one to certainly bear in mind for anybody out there who might be doing any business that does touch on Burma, is that you do need to sort of know ultimately where that's going, and be well aware that if you are dealing in any goods that are subject to the ECCNs covered on Supplement 2, that you need to be very, very careful of that and make sure that it's going to be appropriately authorized.
Yep. No, it's a big issue. I've had it in China all the time, but Burma is one that I think,
less so in Burma, but I have actually had it come up in Burma a couple times.
Yeah. I was surprised they didn't expand on it, because it is one of the big things that that is new and very difficult from a compliance standpoint.
Yeah, absolutely. I'd be interested to know kind of what the data would be in terms of how much business is actually being cut off by virtue of that new wrinkle in the rule, or the extension of the MEU rules to them. I don't know. That's a hard thing to have data on, I think, unfortunately. And we've said this with respect to China and Russia, certainly. It's just it's not a well understood, I think, data set ultimately. And so how you, and to your point, because the rules are a little murky, and because it's kind of a very fact dependent question about what is a military end use, what is a military end user, I think it's hard to know precisely sort of how many transactions or even potential transactions could have been impacted by that.
Yep. No, totally agree. But it was a good guide, very handy.
Agreed.
thank you to the multi-agency effort.
Yeah, thank you to anybody who worked on that over their holiday break to get that done, as we've talked about in the past. So, so with that, we'll end on that. That is our show for today. This will be up very beginning of February in all likelihood. So we will be back mid-February with another episode. I think Tim maybe won't have to wear a hat for the next one because I think he may be south of the border at that point. So, not that it'll be much warmer here, but certainly won't be negative 27, I think.
I'll wear my Nationals cap for the next one.
There you go. That's a little more like it. So, so to everybody, thank you out there for listening. And until next time, hope everybody stays safe and stay sanctions free.
Stay sanctions free, everybody.
Thanks, everyone. Bye.
This podcast was produced by Heartcast Media.